Well, hello again. Welcome to round 3 of the plagiarism controversy. Round 1 was the letters that went back and forth. Let me just show you how you, if you want to look at them, if you want to catch up. Let's see. We are going to share this, and we are going to put it this way. And again, we're doing this just so science can advance. We want to get all the information out there. And if you want to see where round 1 came from, you can go into Real Science Radio and you can search the executive summary. And then you're going to see, let's see here, executive summary. And it's going to be this one, Kevin Lee's Austin Brown mediation thing. And you're going to skip through the yellow part, skip through the letters, and you go down to, I think it's attachment number 1. Yeah, attachment 1, and you're going to see, you can read the letters that went back and forth from in the situation, and then we ended up with setting the record straight. That was round 1, and then round 2 we did. You can go into hydroplate.org. You can go down to the hydroplate resources, down to the hydroplate controversy, click these hydroplate documents, and we did. Let's see, Austin to Brown. I think we did, and we did a bunch of them, and they weren't in order. So you can go down here at the bottom of this one, you find a whole bunch more. So if you're interested in that sort of thing, that's what happens. And so today we are not going to do that. We are going to start the arbitration process has begun. They couldn't settle it privately, so now they've signed on to go to binding arbitration. And this is a letter to David Koppich, March 12th, 1994. Dear David, you will see in my letter dated December 23rd, 1993, to Steve Austin and Henry Morris why you are receiving this letter. They chose you from a list I proposed of 6 people in the Los Angeles area whom I believed we all knew and respected. We are asking you to select a person to make a ruling on a major disagreement described in the enclosed letters. If you cannot do this, then it will be my turn to ask someone else from the list to select the judge. The choice of judge is yours alone to make. We are not asking you to make a ruling. I would hope the person you select is a mature Christian who has no dealings with me or ICR, and who doggedly seek the truth in this controversy. The judge needs to be a strong person who will check details and statements and finally make a ruling on the facts. Hopefully the judge will have such a track record. Perhaps he or she will be willing to largely volunteer their time. Let me make sure you're seeing this. Yeah, you should be seeing this. Okay. Largely volunteer their time. Morris and Austin may not want to subject themselves to the charges I am making, and therefore may not respond to the judge's questions and requests as I hereby commit to do. If so, I, not CSC, will pay for all the judge's expenses up to $1,000. Enclosed are 2 personal checks for $250 and $750. You can immediately endorse the $250 over to the judge you select so the process can begin. If Morris and Austin decide to participate fully, then they should jointly send you like amounts, and you should again give $250 to the judge up front. After the ruling, the judge can assess costs to the 3 of us in a manner he or she feels is fair. Some of us will get a refund. Other than handling the money, David, your involvement ends with the selection of a judge. Of course, you may show candidates any or all of the letters. It is probably best that they not see the enclosed correspondence until they agree to rule on the matter. Matthew 18:15-17 explains why the ruling is necessary. The ruling will be a relatively quick and easy end to this long ordeal. The charges. My first charge is that Steve Austin has made false and damaging statements saying that I took some of his material on the Grand Canyon, and Dr. and Mrs. Block personally heard Austin say this after a presentation he gave Sunday evening, November 3rd, 1990 at the People's Church in Beloit, Wisconsin. Others were standing around listening to an obviously angry Austin. The Blocks live in Rockford, Illinois. Their phone number, okay, we don't need that. And have no idea of how often Austin has made similar accusations or how often others have repeated them. I have heard such stories from others, but the sources either did not hear the statements directly from Austin or they were not willing to tell others what they heard. When I privately asked Austin about this by phone, he denied ever making such statements. Furthermore, he said he never felt that I had taken anything of his. This is significant since Austin might have forgotten what he said, but he probably would not forget how he felt. Austin repeated some of this in his letter of June 21st, 1993. I believe anyone who reads the enclosed correspondence will see why the statements I am alleging have serious consequences beyond me personally, and why I can no longer ignore these false allegations as I did for years. Okay, that's the page. Let's see if they give us the whole letter. I like reading the whole. Oh, yeah, they do. Here we go. Yeah, so this is Center for Scientific Creation, and this is Walt Brown, PhD, going to David Coppage in California. And we read the first page, and now we're going down to the second page. Okay, I can no longer and have serious consequences beyond me personally, and why I can no longer ignore these false allegations as I did for several years. The second charge I'm making is that the Institute for Creation Research Grand Canyon Field Guide Study Tour Guide for 1989 and 1990, Austin has plagiarized from A, me, B, Ed Holroyd, and C, many other researchers. Austin may try to contest A and B. However, I believe that if the judge asks him directly, Austin will admit that he and ICR took copyrighted material from Grand Canyon researchers, incorporated that material, including artwork, into these books without the author's permission, copyrighted that material as belonging to ICR, and then ICR received money for a trip including this book. And then ICR received money for a trip including this book. Austin admitted this to me on the phone. If he denies this copyright infringement to the judge, then I will take the time to go through the reams of material on the Grand Canyon in my library and document specific cases. I will also go into his other writings, one of which he said last summer he would send me, but has not. I also believe that he will now admit making the false accusations to the blocks. Again, he has admitted as much in a recent phone call on February 16th, 1994. Asking Austin these questions may simplify matters considerably and allow us to focus on charges 2A and 2B. There's a third charge. Henry Morris has steadfastly denied that plagiarism has occurred within ICR. His attempt to sweep it under the rug, misstate the problem, or minimize it are obvious. I had hoped he would root the problem out, sensitize his people to its seriousness since it is stealing, and then resolve that it not happen again. This would strengthen ICR and the creation movement. These things do unfortunately happen, and I have never intended to publicly chastise anyone because of it. I simply wanted them to admit the mistake and take reasonable steps to prevent it from reoccurring. I've always been able to accept a sincere admission of error, forget the matter, and then press ahead. In my military career, this happened frequently. In Morris's last letter to me, he reversed himself again on how he would handle this third charge that Harold Schlusser in Age of the Cosmos plagiarized. On July 9, 1993, 3 weeks after first seeing the evidence and denying that Schlusser had plagiarized, he wrote to me that ICR would remove Schlusser's book from its inventory. 2 months later, I bought the book from ICR by phone, thereby learning that Morris had not done what he said he would. In Morris's last letter, January 20, 1994, he reverts back to his position, claiming that Schlusser published a standard derivation. Almost certainly the author you felt compelled to defend, Stacy, got it from somewhere else himself. All textbooks do this sort of thing as far as standard derivations are concerned. Surely you know this. I therefore want to lay this matter in front of the Christian judge. Does Schlusser's book contain plagiarized material? I think this plagiarism would not be obvious to any high school student. Schlusser took almost all of the exact words in sequence, not just equations or derivations, from 2 pages in Stacy's book published 11 years earlier in Australia. Morris needs to hear this from someone he has agreed can rule on our controversy. The judge can easily resolve this by examining the two writings. If Morris honestly thinks the derivation is standard, then he should produce a third author's work showing such startling similarity. Let me take this opportunity to correct several other misstatements Morris has made on this subject in one paragraph of his last letter. Morris wrote me on June 22nd, 1993, that we have never planned to reprint any of them, Schlester's book, that would include Age of Cosmos. Therefore, Morris misstated matters when he wrote me, merely to placate you. However, I agree that we would not reprint or promote the book anymore. Besides this misstatement, the phrase merely to placate you sounds a bit emotional. Okay. ICR could ethically reprint the book if it wished, but it should remove the plagiarized section. It could also write Stacy apologize and a brief errata sheet in each copy sold. Simple. I tried unsuccessfully to reach Slusher last July. However, the burden for answering the charges falls on ICR, since I presume ICR derives all income from the book. D. No, all textbooks don't do this sort of thing, and honest writers certainly don't. E. Morris' claim that I felt compelled to defend Stacy is silly. Stacy is not under attack. What is the judge to do? The judge only needs to tell us in a brief letter whether the charges are correct and whether any misrepresentations have been made by Austin, Morris, or me. For charge 2, there will be 3 answers. Therefore, the judge might conclude on these 3 charges: 1, yes; 2, yes; no, yes; and 3, yes. This can be done any way he or she thinks best. No lengthy justification of the ruling is necessary. The judge will not assess penalties other than costs to pay for expenses up to $1,000. Nor should the judge be concerned with remedies, rules of evidence, jurisdiction, appeals, or attempts to reconciliation. Reconciliation would be desirable after the facts are thoroughly established and the rulings made. Matthew 18:15-17 governs, and Austin and Morris and I have agreed that the judge is acting as the church's representative to decide this matter. As you can see from those verses, it is not required that Austin and Morris participate and cooperate. However, I sincerely hope they do. To help you and the judge visualize the process, David, here are some possible ways for the judge to proceed. Read and reread the enclosed correspondence between Austin, Morris, and me. The issue will become clear with each reading. Compile a list of questions to ask us and others by letter or by phone. Ask us for all relevant material. One key question whose early answer will help me know what additional information to present is, with which of the 5 charges or subcharges do Austin and Morris agree? The judge can seek help from anyone in our presence or not. With which of the 5 charges or subcharges do Austin and Morris agree? The judge can seek help from anyone in our presence or not. Austin or I could probably answer any geological question the judge had, and Morris and I could probably answer other technical questions, all without too much disagreement. Decide whether the 3 of us and the judge should meet for face-to-face questioning. If so, state when and where. Notify us by letter how the judge wishes to proceed. Arbitration versus a judgment. I have delayed writing to you, David, for several reasons. The Los Angeles earthquakes occurred on January 17th, 1994. I know from your phone call to me after Austin had called you that you and your home were hit hard by the quake. It might take many weeks before you could take on the task of finding a judge. I also needed several weeks to decide how we could properly resolve this messy matter. Let me review. On August 19, 1993, I suggested that Morris, Austin, and I put our disagreement in the hands of a neutral Christian arbitrator so we could get a quick and quiet decision. They ignored this suggestion for several months, so I notified them that I would begin showing the file of our correspondence to a few people who had asked me related questions or who had a need to know. Further delays occurred because Morris and Austin proposed arbitrators who were obviously not neutral. First was Emmett William, with whom ICR has had many dealings, many more than I. Then on November 24, 1993, Austin proposed lawyer Stephen E. Hurst, Morris and Austin did not tell me that Hearst had been on ICR's mailing list for years, was a close friend of a lawyer who was employed by ICR for many years, and once legally represented ICR. Why then did Morris write on December 30th, 1993, quote, "The last arbiter I suggested, Steve Hearst, was a person not known by either Steve or me, but one who was recommended to us," unquote. While this may be technically true, it is certainly misleading and raises ethical questions. I appreciate Hearst's honesty by initiating a phone call to me on February 16th, 1994, declaring his connections with ICR. Of course, it would be inappropriate for Williams or Hearst to serve as a judge, even though they had the highest of intentions and integrity. Then Morris and Austin said they would go to arbitration if charges 2B and 2C were dropped and my other charges were reworded slightly. Since we are talking in terms of arbitration, I can see how they mistakenly felt they had some they had some say in what the arbitrator was to decide. I should have been clear when I suggested arbitration. Matthew 18, however, does not give them that option. It clearly says that I am to bring the charges to the church. Since Morris, Austin, and I have now agreed how we can decide who will act as the church, our disagreement can be quickly resolved. Morris's letter of January 20, 1994, now shows that he was never willing to go to arbitration, which by definition is binding, even though he said he was. The remedy I was seeking was a simple apology and corrective steps. Morris wrote, "Even if an arbitrator should decide in your favor, we still could not do this because an apology, would not be the truth." Why we need a clear, well-studied ruling. Most people who have commented on our file of correspondence have concurred with my actions. However, a few have told me that they think ICR has learned a lesson, so I should back off before the evolutionist community learns of this. Although I have many pressing projects and do not enjoy bringing these problems to Morris and Austin's attention, there are important reasons why I must. Number one, Christ told us to. He was quite specific on how we should respond to perceived sin among brothers. The unpleasantness of the task or the hope that a lesson has been learned was not a factor in his instructions. I explained in my letter of December 23, 1993, why the body of Christ needs this feedback system and why its absent produces disease, what I call Christian leprosy. Books could be written about wrongs observed but ignored by Christians that have grown to staggering proportions. Speaking of books, the Bible would be much thinner if its author had removed all unseemly behavior by believers so that non-believers would not learn of it. Speaking of books, the Bible would be much thinner if its author had removed all unseemly behavior by believers so that the non-believers would not learn of it. Number two, I should be made to prove my case. Raising charges is a serious matter, and anyone who does should know that false charges will likely be exposed. If this does not happen with enough frequency in any community, false accusations will become rampant. The 85 words in Matthew handles this contingency beautifully. Morris and Austin should want to test my case in a quiet, closed-door setting before a neutral Christian judge. 3, plagiarism, or even the failure to be diligent in attribution within the relatively small creationist community is more serious than most people realize. This is especially true when the person or organization stealing the ideas has a vastly greater means for disseminating them. Those who are aware of the thefts become more guarded in the free exchange of their ideas of research projects. I have often been asked questions whose answers would involve explaining some unusual and important research. Before answering, I have wondered whether I should be candid, noting that ICR might hear of it, claim it as their own, and then publicize it so widely that I would have to be quiet about it. Worse yet, the situation where one is answering research-related questions before many people. Not 1 in 1,000 in the audience would suspect that a Christian organization might steal ideas or do a poor job of attributing them. The speaker only has a second or two to decide how to respond. He has a responsibility to inform the public. However, the open exchange of research ideas and discoveries before they are published is risky because one unsuspecting person in the audience might talk to someone who later decides he thought of it. If you are candid, you might wonder for years whether a plagiarizer got a hold of it. When you do not open up, you often come across as secretive, non-communicative, and not abreast of the subject. Dealing with classified material in military was much less difficult. Plagiarism within the creation camp stifles the fruitful exchange of ideas among us. 4. Morse's last letter made it clear how ICR intends to describe our disagreement in the future, perhaps for decades. Brown has rejected our last and final offer of arbitration. Brown is unusually sensitive and makes vague, baseless, false, and slanderous accusations that are harmful ICR and the cause that are harmful to the ICR and the cause of Christ. Brown's motives are at least perplexing. Morris may believe he will get away with this because he has the biggest blowhorn. Reputations that others tarnish are hard to restore, especially in my work, most especially when the tarnisher has a wider audience. If the judge makes a clear and complete ruling, can we forestall A, further escalation, and B, the confusion that time and fuzzy memories will bring? I'm very optimistic. David, I hope you will convey to the judge why resolving this disagreement is important. At its roots, this is a case of sloppy attribution procedures followed by attempts to defend ICR by all means. However, the damage has spread, so it is not a minor issue as Morris and Austin have frequently claimed. Nor am I out to get ICR, as Austin told you in his phone call. I want ICR to be as successful as possible and have continually promoted ICR, their work, and their books. Thank you for taking time to consider this. It is sad that this problem has arisen, especially when there is so much on which Morris, Austin, and I agree. I have often wondered how much more could have been accomplished if trust and open communication had existed these last 14 years. It is quite likely that with your help, David, healing may occur. But first, we need 5 yes-no decisions. I hope you can find a qualified judge. Sincerely, Walt Brown, CC'd Henry Morris and Steve Austin. And enclosures are and we read some of these. We read Brown's letter in June, Brown to Austin in June 18th. We read Austin to Brown in June 21st. We read Morris to Brown in June of 22nd. Brown's report to Austin and Morris, amended in November 29th. I think this was to straighten the truth or something like that. Morris to Brown in July 9th, I believe we read. Austin to Brown dated July 11th, but delivered August 16th. Sounds familiar? Brown to Austin. Let's see. Yeah, we read a lot of these. And yeah, so that's what we have. And then 2 checks from Walt Brown to David Coppage. So this is the letter to whoopsie. This is the letter to David Coppage. And I believe he was let go from the Jet Propulsion Lab because he gave a creation video off hours. Okay. Book court issue from June, September 1994. Let's take a look at that. Book count issue. June. What's the date on this? September 30th, 1994. I think we want to get are we doing this in backwards order? Yeah, let's see once. Memorandum. Okay. Morris to Brown, 120. Did we do this one? Yeah, we've done that one. Okay. So that's their attempt to find an arbitrator. Okay, let's see. Let's back out of here. Okay, that's Coppage. And this is the mediation ruling, September of 1994, September 21st. What was this one? What were these at the bottom? June to September. Okay, yeah, we'll do this one first then, I guess. Book count issue from June, September 1994. Personal memorandum of mediation between Brown and Morris, Austin, which was conducted June 22nd, 1994. Notice it is not arbitration. This is mediation. So whatever happened there. Yeah, what happened? Brown to Coppage. Yeah, I think we did that one. Yep, we did that one. Brown to Coppage. Mediation. Okay, I think this is what we want to do. Personal memorandum of mediation between Brown and Morris, Austin, which was conducted on June 21st, 1994. So apparently, if I understand it properly, they signed up for binding arbitration, and then they canceled it 4 days before the event. And so then they offered mediation instead of arbitration. And Walt reluctantly agreed to mediation. And this is what the mediation says. Let's see, these are photocopies, I believe. Okay, so this is what the mediator says. Oh, okay, you know what? Yeah, I think we're going to stop the live screen here. Okay, we did that. Okay, let's see, remove this. Okay, so that's the arbitration letter. And so, and again, they backed out. And again, why are we doing this? We want the hydroplate theory. Oh, let's take a look at the comments. Want to here. Okay. All right. Yeah. So we've got this. So basically what we want is light to shine on this so science can advance. We are not trying to hurt anybody or any organization. Actually, I have a lot of respect for ICR because the current president invited the hydroplate people to come in and talk to his scientists. And at the beginning of it, he said, this is to fix an injustice. Okay, so that's great. You know, and I think there might be some resistance in organizations. I know of a president of another organization who wants to learn more about the flood models, but the CPT people do not step up to the microphone. And they want to do it in private, and that would be fine. And one of the CPT experts, he wants pre-approved questions before he sits down. And I'm thinking, man, if you're the expert, you should be able to answer any question anytime. And so this was the letter for an arbitrator. Again, that fell apart. And we'll stop this. This was round 3. And let's go to round 4, and then we'll see what the mediator decided. So I'll be back in a few minutes. Thank you for your interest in this. And what can people do? This is a grassroots movement. We need people to start asking about the hydroplate. This is a theory that logically explains 25 major features on Earth and in the solar system, and yet it's being ignored by secularists and creationists alike, and it's hurting the cause of Christ. This is a powerful witnessing tool, and it's being ignored. And I think this is why it's being ignored. They don't want to deal with this. And even today, even this year, there's been some horrible things said about Walt Brown. And so we want to get this issue dealt with, and we want light to shine on this. So again, what can you do? You can start asking about the hydroplate at creation speakers. You can start asking about it at creation museums and encourage them to put in both models. Put in both flood models so then people can think about the flood models instead of just seeing a secular model sped up that doesn't make predictions and that doesn't have any specific biblical support. And so I think if enough people start asking this, I think there can be a change, and then science can progress, and then more people can stop doubting the Bible and start believing in Christ, the Savior. And so thank you so much. We will be back in just a few minutes looking for round 4, which is what the mediator decided in this thing 32 years ago, 31 years ago. So we've been patient. People have been very patient, and patient hasn't gotten us anywhere. So it's time to shine some light on it. So thank you for your interest, and we will hopefully see you in a few minutes.